and have violated the record of proceedings, put it on the ethics.
I'm sorry to interrupt your worship. We are at a loss as to what is going on. Is he proceeding with the matter? Is he not proceeding? What are we here for? Because what we are listening to does not add up to us.
Your worship, I'm just bringing you to speak because we're not part of this application. And I think I'm in order.
But there is a record, there is a file, there is a matter before you court. Why don't you?
So, when this court allowed counsel for defense in the necessary judgment intimated that the court that they had filed an application for review in high court. But it has never come to pass. So our prayer today, Your Worship, is that it looks like there is no such application in the High Court, and as such we pray to have this matter fixed for hearing. It's okay.
May it please Your Worship. Just for the record, whatever he has said here is neither here nor there. The application is there. The application number was presented to this court, and even as the copy was supplied to the court. So that is absolute hogwash. To say the least, it's absolute hogwash that we do not file the application, and it's misleading court. But that's shape for the proceedings of today is seeking to proceed. Your Worship, we would like to go on record, and we have a prayer to make. We have received instructions from the respondents, the applicants, Your Worship, to ask you to recuse from this matter. Your Worship, if it pleases you, these are the following grounds. One, Your Worship, we have gotten instructions to raise a complaint against you before the Judicial Service Commission. On grounds of maladministration of justice, incompetence, and abuse of a judicial oath. Your Worship, a copy of the complaint which is already filed before the Judicial Service Commission is here for record purposes. Your Worship, you may substantiate the accused or the respondents in this matter have gotten reasonable fear and apprehension that you do not have the requisite competence to adjudicate a matter of this nature and to dispense justice. considering the antecedents and the proceedings that have happened before. First of all, the propriety of these proceedings, Your Worship. Being manifestly unconstitutional. The last time the matter appeared here, the state indicated that they had finalized all the investigations they wanted to conduct and proceeded with the committal proceedings, Your Worship. Under Section 168 of the Magistrates Court Act, Your Worship, this Honorable Court ceases to have jurisdiction over a matter that is triable by the High Court upon conclusion of the pre-trial processes. Once the state has summed up its case, prepared the committal papers, and the file is forwarded to the High Court for purposes of the trial, this Honorable Court is deemed to have exhausted its jurisdiction and has no residual powers whatsoever to handle any interlocutor application like this court is purporting to do. It's the first of its kind. If I may bring myself into the picture of the proceedings. In my 28-year practice, I have never witnessed such kind of proceedings. And I'm sure many lawyers will attest to this fact, including judicial officers, that after committal proceedings are done, that there can be any other application to be entertained by a chief magistrate whose jurisdiction is restricted to pre-trial processes. This is that the respondents here are convinced that, Your Worship, that you have demonstrated gross incompetence in managing a matter of this magnitude with a grave offense that has far-reaching implications as far as their lives are concerned, which carries a death sentence. In other words, a death sentence means quite a lot. The other ground is the failure by this Honorable Court to comply with the dictates of the Constitution under Article 23 and Section 76 of the Constitution, rather of the Magistrates Court Act, which provisions were cited before you, Your Worship, and they are couched in mandatory terms. That once an accused person has clocked 180 days before committal, then mandatory. And this Honorable Court cannot conduct any other business apart from addressing itself to the question of mandatory bail. And the practice guideline, this is what now we wanted to bring in, Your Worship, particularly guideline number 10.2, paragraph 2, which requires you, if you decline to grant mandatory bail, to forward the file to High Court. So that's, Your Worship, you did not pronounce yourself on the question of whether the accused persons have spent more than 180 days on remand or not. You have never ruled on that matter. You have never made any ruling. In which case, you will proceed to determine whether they are entitled to mandatory bail or not. If you find that actually you lack the requisite jurisdiction because of the repugnant practice guideline, yes, you fall back on that guideline 10 and forward the file to High Court. That was never done. That is also an act of gross incompetence on the part of the applicants. Finally, Your Worship, the applicants are relying on the authorities of Attorney General of the Republic of Kenya, the applicant, versus Professor Anyang' Nyong. This is an East African case. This is the East African Court of Justice at Arusha, application number 5 of 2000. Their Lordships had this to say, that for the purposes of the application for recusal, we do not find it necessary to direct that Dr. Priya addressed us on at length. We think that the objective test of reasonable apprehension of bias varies, but amounts to this: do the circumstances give rise to a reasonable apprehension in the view of a reasonable, fair-minded to the case impartially? Needless to say, a litigant who seeks disqualification of a judge comes appearance of bias on the part of the judge. The court, however, has to envisage what would be the perception of a member of the public who is not only reasonable but also fair-minded and informed about the circumstances of the case, what they would be. Of it's a Bristol Betting and Game Licensing Committee. It's an expert application. This is the common law principle. I mean, this is an English decision. It was the Supreme Court. And the principle they cited, the House of Lords, is that the policy of the common law is to protect litigants who can discharge the lesser burden of showing a real danger of bias without requiring them to show that such bias actually exists. The point here, Your Worship, is that an application for recusal is largely premised on the perception of the applicants, of the accused persons, whether indeed this court will dispense justice or not. And in this particular case, Your Worship, on the basis of these authorities and the evidence before you, the accused persons are convinced beyond all shades of doubt that you will not dispense justice in a free and fair manner, or impartially, having manifestly demonstrated bias against them, and also ignoring the dictates of the Constitution to the extent that they are now languishing at Ruzira without exactly knowing what their fate is as far as mandatory bail is concerned. They don't know. After clocking over 180 days without committal, they don't know. So we do pray that your worship will be pleased to recuse yourself and terminate these proceedings properly. We so pray.
Your worship, I wish to join issue with Senior Counsel Elias Lukwago and state that for the record, by and to now, Your worship, in further submission to our application for recusal and proceeding under Guideline 7 of the Constitutional Recusal of Judicial Officers Practice Directions of 2019, the Constitutional Recusal of Judicial Officers Practice Directions of 2019, wherein Section 7 states, Guideline 7 states that a party to proceedings may apply to a court for a judicial officer to recuse him or herself under the following circumstances, and we are interested more in sub-guideline E, that where a judicial officer makes inappropriate comments or exhibits unacceptable conduct in the course of the hearing, and in F, where a judicial officer exhibits actual, implied, or apparent bias, then they are bound to recuse themselves. Your worship, appropriate comments that our clients think that should be the basis of your recusal are when you stated that A1 and A2 waived their right to legal representation by telling their lawyers to do what is more urgent at that time, and it was your view in open court, and the record shows that you stated that they waived their right to legal representation. Your worship, we bring it to your attention that under Article 23 and Article 28, 3E, a right to legal representation in a capital offense can neither be derogated or waived by an accused person. And it is the reason why that specific article provides that in circumstances where private legal representation is not available, the state must avail or provide a lawyer to an accused person where the offense can lead to death. And I beg to read the specific clause in verbatim. That in the case of any offense which carries a sentence of death or imprisonment for life, the accused person shall be entitled to legal representation at the expense of the state. That not at any one point can an accused person waive his right to legal representation in a capital offense nature that can arise to him being convicted and sent to death? That in any instance where he or she cannot afford, no private lawyers are not present, the state shall provide a lawyer to make sure that the right to legal representation is upheld at all times, Your Worship. That position was stated further by the Constitutional Court in the decision of Grace Peter and Fred Varium Maisho versus Attorney General. Accused persons were charged with the offense of murder, and it was stated that a right to legal representation which rationale is provided for in Rule 6.1 of the Judicature legal representation at the expenses of the state, Rules 2022, that the accused person shall remain represented pre-trial and during the trial, and where applicable, post-trial in capital offenses. Submission is that that right can never at any one point, and if this court at any one point wishes to form an opinion that since pre-trial is not the actual trial, that decision and the rules resolve that to say that the accused person shall remain represented pre-trial, during the trial, and post the trial by legal representation. And if there is no availability of a private lawyer, the state shall provide a lawyer. And therefore, in summing up, we find comfort in the authority of Eastern and Southern Africa Trade and Development Bank and another, Eastern and Southern African Trade and Development Bank and another, versus Martin Ogang, wherein the test for recusal was explained to say, on page 7 at paragraph 34, that the test is not whether reference number IB, Eastern and Southern African Trade and Development Bank and another, versus Martin Ogang, reference number IB 2000. And the issue was recusal of Mr. Justice Ogola from the case. And the test is where it was explained to state that the test is not whether Mr. Justice Ogola can disabuse his mind of any knowledge he may have of the respondent, but rather whether a reasonable man having this background information would reasonably suspect the possibility of bias on the part of Justice Ogola. Court reflects that passage. The test is not to as whether Mr. Justice Ogola can disabuse his mind of any knowledge he may have of the respondent, but that whether a reasonable man having this background information would reasonably.
Why we have the copy of what we are saying in our hands.
Thank you. Thank you, and we shall avail. You don't need to be in a hurry. Background information would reasonably suspect the possibility of bias on the part of Justice Ogola. And it's our firm submission on the instructions of our client that if any reasonable man has been in court present in conduct of these proceedings, they would form a view that the judicial officer, who is you, your worship, is biased. And therefore, the requirement and to protect the sanctity of the rights of the accused persons is that you recuse yourself. But if that argument is disregarded, the fact, much obliged, Your Worship, the fact that you are now a respondent with the applicants in a complaint at Judicial Service Commission is sufficient that you cannot now dispense justice against a person who has complained on both your conduct and your competence. Judicial officers are not robots, they are human beings. And therefore, we beg and pray that you recuse yourself from this matter for it to proceed independently and impartially. Much obliged, Your Worship. We object, and if the law still works in this court, which we are not sure about by the conduct of the last proceedings, the rules I've just cited and the ones we are proceeding under, which are the rules of recusal, do not envisage under any circumstance where a state responds to an application for recusal. The rules and the procedure for recusal in instances where a party arises is that the party rises, the judicial officer has an opportunity to respond, not a state attorney. And therefore it would prejudice our application if the rules are not followed to the ultimate realm, and we pray that they operate in this court for at least today. The state attorney does not or is not given leverage, and I will share the rules if he does not have them, much as I thought they are public documents which you should have. They do not envisage a state attorney responding in such an application, and we pray that you, the judicial officer, you respond, and we shall be happy if you recuse yourself, and if you don't, we shall now seek other avenues. But we pray that he does not respond and the rules operate in this court for today. Much obliged.
Trained in this matter to take two drastic steps. One, to drag the trial magistrate here. I don't know whether she's even still a trial magistrate, to the Judicial Service Commission on grounds of incompetence and demonstration of bias in the matter and failure to impartially dispense justice. The other step we have also taken is to ask her to recuse herself from this particular matter because of apparent bias and incompetence. She has indicated she is going to deliver a ruling on the 26th day of this month. So hopefully she will take the right decision, because this is a serious matter which touches the lives of our clients. It's a matter which is extremely delicate. It's a grave offense which invites a sentence of death in the case of conviction. So that's how serious it is, and we don't want anything to be, handled in a manner which is not satisfactory. That's why we cannot leave any stone unturned in pursuit of justice for our clients. So this is the full length we have to go, and we are ready for a long haul in this matter, because it would appear this court now is becoming another kangaroo tribunal, like the General Court Martial, where Dr. Besigye and Obedi Lutale were arraigned before. You remember how we labored, how we struggled, how we waged a protracted battle to get out of the General Court Martial to come to civilian courts, where we thought at least there is some breath of fresh air, that there would be justice, that there will be respect to the dictates of the Constitution. But Allah, she's turning out to be like Franco Mugabe. This magistrate is becoming another Franco Mugabe, the one of General Court Martial. Flagrantly disregarding mandatory provisions of the Constitution, like Article 23, which talks about mandatory bail after one has clocked 180 days on remand. It's couched in mandatory terms, including the Magistrates Court Act, Section 76, which dictates that once one has spent more than 180 days on remand, no any other business you are going to conduct, save for considering the application for mandatory bail. As we speak today, she has even dismally failed to pronounce herself on just a simple matter of computing time, computing the period the accused persons have been on remand. Let alone doing a simple thing which is provided for in Regulation 10 or Guideline 10 of the practice guidelines that were given by the Chief Justice, that in the event that the trial magistrate who is conducting the pre-trial processes in a capital offense like this one find themselves in a situation where they have one accused who has spent more than 180 days on remand before committal, you forward the file to High Court. We ask for just a simple thing, that kindly submit the file to High Court for purposes of processing mandatory bail for Dr. Besigye and Obedi, and she declined in total disregard or blatant disregard of the express provisions of the Constitution. So this is gross incompetence. The other thing is about legal representation. I think all the issues, as you heard here, we have succinctly raised them, that a matter of this nature, which invites a death sentence or capital offenses like this one, you cannot in any way proceed with an accused unrepresented. Actually, the law dictates, that is the Constitution. In the event that an accused person does not have a private lawyer, the state is duty bound to provide one at their expense, and rather actually at the expense of the state. That's how serious the Constitution is. So it's on record. On the day of committal here, the council who are here were really not satisfied with the conduct of the matter, and they withdrew from the bar. So, subsequent to the withdrawal of counsel from the bar, what the magistrate ought to have done within the parameters of the law was either to adjourn the matter to allow the accused persons get another lawyer, or get one for them at the expense of the state. But she did the unthinkable in unobdurate disregard of the dictates of the Constitution. Said, you opted to waive your right for legal representation. It was an absurdity, a travesty. So she proceeded to commit the accused persons without legal representation. That is a terrible, terrible violation of the judicial oath. How can you do that? A magistrate who is addressing yourself and your mind to the law, you can take such outrageous decision. The final one is about this application. It's outrageous. I am telling you this. This is a case in a class of its own. It has never happened. It has not happened anywhere in our jurisprudence, in our criminal justice system, that you commit accused persons to high court for trial, and then you open up the matter for an interlocutor application to allow the state to continue with the investigations. The import of committal proceedings that the state is done with investigations. That's why actually the Constitution gives them the latitude of using like 6 months, 180 days within which to conduct investigations. And the reason they are pre-trial processes conducted before magistrates in a matter which is triable by the High Court, that the High Court is saved the burden of going into issues to do with the investigations, managing the pre-trial processes, and what they say, okay, those pre-trial processes, let them be handled by magistrates' courts. Once the file is well assembled and ready for trial, forward it to High Court. And that's what the state did the last time we appeared here. They indicated they were done with the investigations, they had summed up their case, they had assembled the necessary evidence, and they were good to go. They were set to proceed with the hearing. Now, this application, which was coming up today, is seeking to reopen up again investigations to allow the state to access data on Besigye's phones and Obed Rutare's. Can you imagine? So, one would ask, and for heaven's sake, I shouldn't even be asking this question. Once you allow them now to open up the phones and access data, what do they do with whatever evidence they are going to gather after committal? Because you have already made the committal proceedings. You have already forwarded the High Court to, you have already forwarded the file to High Court. It's already before High Court for trial. Now, whatever evidence they are going to gather subsequent to the committal, to what effect? Is for what purpose? So it's just even a matter of logic. You, even non-lawyers, you can even tell that actually what she's doing is irregular. So it's the reason our clients, not we as lawyers, our clients deemed it appropriate to drag the magistrate to the Judicial Service Commission for disciplinary action because of that gross incompetence and abuse of the judicial oath. And also, we are instructed to seek for a recusal. Rather, to seek a recusal, which we have appropriately done here.
If I ask you only one question, if I heard you very well, you talked about the issue of judicial malpractice. What do you mean with that in your submissions?
That is how the law is coached. Judicial maladministration of justice. You see, it's about failure of the judicial officer to dispense justice in accordance with the law. Yet once they take oath, the judicial oath, it's all about that. We will uphold the law, to dispense justice in accordance with the law, which has dismally failed to do.
Honorable, before we go to Uganda, you put at the Judicial Service Commission, but the court went ahead and convened. Had they not known of the steps you had taken? And now that you have informed them of the way forward, what is the way forward?
Well, I will start with the way forward. We are just waiting for her decision on the 26th day of this month, because we have made our case, or the case for our client has been made, and I think we have done our best under the circumstances. We have executed our duties. We have indicated to her that after committal, she has exhausted her mandate. She has no jurisdiction whatsoever. She has no residue powers to conduct any business concerning Dr. Besigye and Obed Rutale matter. She has no business with Besigye. No business at all. This is what we are telling her. So to purport to come up with that application is abuse of the judicial oath. And now you are asking, yes, was she aware of the complaint we took to the Judicial Service Commission? That much, well, we don't know because we served the court. That was this morning, but we supplied her with another copy. So it's okay. Whether she has convened or not, at least now she knows that there is a matter against her before the Judicial Service Commission, where now the accused persons or the applicants, Dr. Besigye and Obed Rutale, are taking her on. So now it's a matter, there is a case now before the Judicial Service Commission between Obed Rutale, Dr. Besigye, and the magistrate herself. So until that is resolved, definitely she cannot proceed.
Lord Mayor, tugende mu Uganda.
The mayor goes for Uganda, the non-lawyer should also speak.
Let's first
The one they
finish
referred
with
to.
Uganda.
Because
We shall come back. Lord Mayor
Let him speak. Suppose after speaking, we know
is she biased?
I'm not biased, but the Lord Mayor said that
Can she recuse herself?
on what grounds?
You can remove your camera. I just wanted to say, because he asked me to speak, he called me from court. I just wanted to say that from the non-lawyer perspective, that judicial power is derived from the people of Uganda. And therefore, that must be exercised without bias, without personal interest, without emotions. And therefore, as non-lawyers, when we see somebody who holds judicial power putting in emotions and personal interests, we don't even need to be lawyers to know that such a person should not be in such a position. And so I am happy that the lawyers have applied for her to excuse herself, and that's what it is supposed to be.
We have an interview. You don't
Sure,
do,
you should be having.
I don't do media interviews.
Okay. Let's. In your submission in court, you said the state, in such a manner, they can't respond to you people. Only what they have is to keep quiet. You could only hear from judicial officer. And you saw how they struggled. Explain to me the basis of your submission in law.
Okay, thank you so much, Solomon. What we were handling here today was an application for recusal of a judicial officer. Now, in such an application for recusal of a judicial officer, that application is between the party who has raised that issue and then the court. Now, in that regard, there is no circumstance under the rules, and specifically we're using the rules, the guidelines we have for judicial officers recusing themselves. There is nowhere in the rules, the procedure is clear under guideline 7 to say that the party will raise the recusal motion, the court shall respond, and after court responding, it shall give a ruling on whether to recuse itself or not. Now, there is nowhere in that specific rule where they say the state shall respond, because it ceases to be a matter against parties, it becomes a matter of a party with the court, not with the state. So it ceases to be inter-party, but therefore that was the basis of our objection of the state attorney not responding to our application for recusal.